evening. So the topic which I am going to review today is emergency provisions under Indian Constitution. So let's begin with the question, what is an emergency? And the term emergency may be defined as a difficult situation arising suddenly and demanding immediate action by public authorities under powers especially granted to them by the Constitution or otherwise to meet such exigencies. This is a kind of definition which can be given to the term emergency. Now, emergency provisions are contained in Part 18 of Constitution from Article 352 to 360. So the rationality behind the incorporation of these provisions is to safeguard the sovereignty, integrity, unity, and security of the country. So let's see what are the three type of emergencies. In India, three type of emergencies are available under Indian constitutions. These three emergencies are, one, it is national emergency, which is dealt under Article 352 of Indian Constitution. Then comes state emergency, otherwise it can be called as failure of constitutional machineries in a state, which is under Article 356. And finally, financial emergency under Article 360. These are the three types of emergency which is existing in India right now. Now, let's see national emergency in detail. National emergencies is dealt under Indian Constitution under Article 352. If the President is satisfied that a grave emergency exists whereby the security of India or any part of the territory thereof is threatened due to the following reasons, the President can proclaim national emergency. See, three situations are: one, due to war; secondly, due to external aggression; and third one, armed rebellion. The point which there we have to notice that the word armed rebellion was substituted for the term internal disturbance by 44th Constitutional Amendment Act 1978. Now, under Article 352 Clause 2, the proclamation of emergency made under Clause 1 may be revoked or varied by President by a subsequent proclamation. Under Article 352 Clause 3, the President shall not issue a proclamation unless the decision of Union Cabinet that such a proclamation may be issued has been communicated to him in writing. Or otherwise, I can say that the President shall not issue a proclamation unless a decision of Union Cabinet that such a proclamation may be issued has been communicated to him in writing. Such a proclamation may be made even before the actual war, external aggression, or rebellion, if the President is satisfied that there is imminent danger thereof. So the Union Parliament acquires the power to legislate on any subject included in the state list. Emergency legislation ceased to have any effect at the expiry of 6 months. That means the emergency legislation ceased to have any effect at the expiry of 6 months after the proclamation ceased to operate. Now see, during the time of national emergency, fundamental rights are being suspended. But except Article 20 and 22, that means Article 20 and 22 cannot be suspended during the time of the proclamation of national emergency. And one more point is there. The President has the power to suspend the right to move to courts for the enforcement of any of the powers, means suspend the right to move to court for the enforcement of any of the fundamental rights for a period not exceeding the proclamation of emergency under Article 359. And every proclamation is required to be laid before each house of the Parliament and is ceased to operate at expiration of 1 month from the date of its issue, unless in the meantime it has been approved by resolution of both the houses. However, once approved by Parliament, the proclamation may continue for 6 months at the time, unless revoked by President earlier. So that is another important point. Now, under Article 352, Clause 6, it says that a resolution approving the proclamation has to be passed by special majority. That is, by a majority of total member of each house and also by a majority of not less than two-thirds of members present and voting in each house. Now, there are more amendments are made in the provision of national emergency by 44th Amendment. So let's see what are the important amendments made in national emergency. So first point is the word armed rebellion were substituted for internal disturbance in 44th Amendment. Second point, clause 3 was added to Article 352, which states that President shall have declared national emergency only on the written advice of the cabinet. This was done after Indira Gandhi versus Raj Narain case. See, another important point is the 38th Amendment Act of 1975 made the declaration of national emergency immune to judicial review. And after that, through the 42nd Amendment, Article subclause 5 was inserted in Article 352, which made the president satisfaction in proclaiming an emergency final, conclusive, and provided that such satisfaction shall not be questioned in any court on any ground. So that was the situation that time. It was clearly meant to exclude judicial scrutiny of a proclamation or its continuance. Then what happened was that in 44th Amendment deleted the 5th clause of 352, and this itself shows that at any rate of justification of court to go into the malified issue of a proclamation. So that is one among the important amendment made in 44th Amendment Act 1978. Now, in Minerva Mill case, AR 1980 case, the Supreme Court held that national emergency can be challenged in the court on the ground of malified or that the declaration was based on wholly extraneous or irrelevant facts. In another case, in Sabarnanda Sanoval versus Union of India's case, Supreme Court for the first time got an opportunity to interpret the word aggression used in Article 355. Now let's see how many national emergencies so far declared in India till date. First, in 1962, at the time of Chinese aggression. Secondly, in 1971, in the wake of war with Pakistan, and in 1975 on ground of internal disturbance. These are the three instances in which national emergencies have been declared till date. Another important point there we have to notice that Article 358 says that things done or omitted to be done during emergency cannot be challenged even after the emergency was over. So now let's move to President's rule in state. That means state emergency. It is dealt under Article 356. So there I have quoted Dr. B.R. Ambedkar's words. He says that Article 356 should normally remain a dead letter and would be used only as a last resort. So that much care and caution should be given before the proclamation of state emergency. See, Article 356 says that failure of constitutional machinery in a state. The Constitution provides for carrying on the administration of a state in case of failure of constitutional machinery. Article 356 clause 1 clearly says that the president is empowered to make a proclamation if on receipt of record from the governor of a state or otherwise he is satisfied that the government of state cannot be carried on in accordance with the provision of the constitution. Now, uh, see, uh, these are the following consequences ensue on the issuance of proclamation under 356 clause 1. That means, first one, president may assume powers vested in governor. Number 2, president may declare that powers of legislature of state shall be exercisable by parliament. Number 3, the president may make such incidental or consequential provisions as may appear to him to be necessary or desirable for giving effect to the object of proclamation. The president cannot, however, assume to himself any of the power vested in High Court. So, next slide says that by the proclamation under Article 356, the power of the state legislature are to be exercised by the parliament. Next point is, parliament may delegate the power to make laws for the state to the president or any other authority specified by him. Next point, the president can also issue ordinance for the state under Article 123 when parliament is not in session. And last point in this page is, the proclamation issued under Article 356 clause 1 may be revoked or varied by president by a subsequent proclamation. Now let's see what is the duration of proclamation of state emergency under Article 356. See, Article 356 clause 3 says that it shall be ceased to have effect at the expiry of 2 months. If the Lok Sabha is dissolved during this period of 2 months and the proclamation is passed by Rajya Sabha but not by the Lok Sabha, the proclamation shall cease to operate at the expiration of 30 days from the date on which the new Lok Sabha meets. Now, Article 356 clause 4 says that duration of proclamation can be extended by 6 months each time by both House of Parliament. Maximum period for which a proclamation can remain in operation is 3 years. Article 356 clause 5 says that beyond 1 year, a proclamation can be continued only if emergency under Article 352 is in operation in the whole India. Now, see what are the proper grounds for evoking state emergency. There are a number of grounds for evoking state emergency. Some among them are hung assembly scenarios, then corruption, maladministration, then acting contrary to Constitution of India or union directives, then failure to meet an extraordinary situation in a state, then security concerns of the state, then breakdown of law and order, then political instability, and so on. Now, S.R. Bommai versus Union of India, AR 1994, Supreme Court 1980 is one among the important case laws which lay down various guidelines in regard to the use of Article 356. So, some of the guidelines are here. One, it should be used, that means state emergency should be used as a last measure to restore the constitutional machinery in a state. Number 2, the power granted under Article 356 is not absolute. Number 3, High Court and Supreme Court can strike down the proclamation as unconstitutional if it is nullified. Number 4, President shall exercise the power under Article 356 only after the both house approves it. And sixth point is, in case both house do not approves it, the proclamation will cease to be effective on the expiration of 2 months. And some more points are there. In case proclamation is approved by both house within 2 months, then the government which was dismissed will not revive on expiry of 2 months. If the courts, that means Supreme Court and High Court, strike down the proclamation It has the power to restore the dismissed government and reactive the legislative assembly. So the court in SR Bommai case gave other instance where evocation of Article 356 would be proper. In another case, in special reference number 1 of 2002 in Gujarat Assembly election matter case, the court held that the question of declaration of state emergency under Article 356 has no relevance to fixation of election schedules. In another notable case, that is Rameshwar Prasad versus Union of India, AR 2005 Supreme Court 4301 case, the court held that the governor cannot assume to himself aforesaid judicial power, and based on that assumption come to the conclusion that there would be violation of 10th schedule and use it as a reason for recommending dissolution of assemblies. Now, the third emergency, that is financial emergency under Article 360. The president is authorized by under Article 360 to declare by a proclamation financial emergency if he is satisfied that the financial stability or credit of India or any part of its territory is threatened. It has not been laid before it has to be laid before both House of Parliament and cease to operate at the expiration of 2 months unless meanwhile approved by the resolution of 2 houses. Once approved by the Parliament, unlike a proclamation under Article 352, it may continue indefinitely until revoked or varied. And during the operation of financial emergency, the executive authority of the union extend to the giving of direction to any state to observe certain specified canons or financial propriety and such other direction that the president may find necessary or adequate. These declaration may include reduction of salaries or allowance of all those serving a state, and reserving for the president's consideration all money bills and other bills under Article 207 after these are passed by the state legislature. The president may also direct reduction in salaries, etc., of all those serving in connection with the affairs of union, include judges of Supreme Court and High Court also. So thus far, there has been no occasion for promulgation of financial emergency in India. So this is all about my topic. Thank you.
Provisions ഇപ്പോൾ അതിനത്ര റെലവൻസി ഇല്ല, ബിക്കോസ് അത് അറ്റ് ദ കമൻസ്മെന്റ് ഓഫ് ദ കോൺസ്റ്റിറ്റ്യൂഷൻ വേണ്ടതാണ്, അല്ലെങ്കിൽ 5 year വരെ എക്സ്റ്റെൻഡ് ചെയ്തിട്ടുള്ള പ്രൊവിഷനാണ്. പിന്നെ അതിന് റിലവൻസി ഇല്ല. പിന്നെ ഒരു